The record in the matter of the people of the state of Michigan versus Sandra Baxter, file number 24-00482. Council appearance.
Good morning, Your Honor. Stephen Graham, P51260, Assistant Attorney General on behalf of the people.
Good morning, Your Honor. Michael Anderson on behalf of Miss Sandra Baxter, who does appear via Zoom.
Was the date and the time to conclude with the decision as to whether or not this matter should be bound over to the circuit court? Parties given their bind over argument or opposition and argument at the last date. Was there any additional argument that you wanted to make today?
No, Your Honor.
Mr. Anderson?
No, Your Honor.
The courts had an opportunity to review the exhibits which were admitted in this file. And having reviewed that, I'm going to advise Ms. Baxter. And Ms. Baxter, I believe can hear me. I just muted her because of the feedback. Ms. Baxter, you can nod if you can hear me. Ms. Baxter, can you hear me? Can you raise your hand if you can hear me? Thank you. Okay. And so, Ms. Baxter, for your understanding and purpose, this was a preliminary examination. So the purpose of the preliminary examination is to require the prosecution, which in this case is the Office of the Attorney General, to put forth evidence that would establish that they have sufficient probable cause, that a crime was committed and sufficient probable cause to charge you with those crimes. This is not a trial. They do not need to prove each element beyond a reasonable doubt. What they needed to put forth was a very low burden, which is more than mere suspicion that those crimes alleged occurred and that you were the person to commit those crimes. And so the court will be the sole determiner of any credibility of witnesses. And I've reviewed the evidence as well as taken into consideration the testimony of the witnesses at the time that we presented proofs. And so based on the evidence submitted as well as the testimony, the court is satisfied that the prosecution has laid sufficient probable cause in this matter. Again, this is a complaint that charges Ms. Baxter with one count of prosecutor's investigative subpoena perjury, a felony, maximum penalty 15 years in prison. We had testimony from an employee of the Michigan Office of the Attorney General, I believe it was Alexandria Casperson. Okay, I couldn't look like spell her name right. I think it's supposed to with a C. Alexandria Casperson. There was a testimony about her investigation into the initial concern. There was testimony from Jennifer Kapuscinski, thank you, who gave testimony about the articles of organization that was filed by the defendant in search warrant for the bank records, and then reviewed the extensive information that was provided from the prosecution. There was some exhibits also stipulated to and exhibits submitted by the defense. The court is satisfied that there is sufficient probable cause for the matter will be bound over. The bind over date is going to be August 21st. And so that's the date that the circuit court is going to get the file from the district court. They will not require your presence in the circuit court on that date because you will not be rearranged unless your attorney is making a special motion to have you rearranged at the circuit court. Otherwise, your next court appearance is going to be for a pre-trial at the circuit court. Your attorney will be made aware of that date. You can unmute Ms. Baxter if you have any questions.
No questions.
Okay, bond in this matter was set at 1,000 personal. We're cognizant that will continue. Are any additional matters for today's record?
May I receive the exhibit?
Absolutely.
Thank you.
Nothing further, Your Honor. Thank you.
You're all set. It's back as well. I don't have any notes on it.
Your copy. There was also a copy already in
Oh,
the
there's
exhibit
one.
binder.
That's my copy. Okay. There's that.
May I approach the floor?
Yes, thank you.
Thank you.
Okay. Okay, on the record in the matter of the people of the state of Michigan versus Heather Lombardini, file number is 24-00510, council appearance.
Morning again, Your Honor. Stephen Graham, 251260, Assistant Attorney General on behalf of the people.
Your Honor, Gallup Fish on behalf of the people as well.
Good morning. Tom Cranmer appearing on behalf of Mrs. Lombardini, who is seated next to me, counsel.
Okay, today was the date set for a motion, and this is for Ms. Lombardini's motion to dismiss the complaint. And the court has reviewed your motion and your reply. However, the concern the court has is I don't have a reply from people. Did you file a reply, a responsive
She
motion?
did, Your Honor. Should be a brief file. June 26th.
Okay.
Something on July 8th.
Hmm? Yeah, I have it July 8th, but that was the defendant's. I don't have anything. I don't see anything in JIS. No, we don't have anything in JIS that we received anything from the people.
I know that's what the July 8th response was to.
It was apparent that they had received a response by, but I don't have anything. I have what was filed on May 14th. Then I have what was filed in response to whatever you respond on the 8th. We don't have anything. What did they send it to? How did you file it?
Let me see. I know originally she tried to file it by e-filing and it was rejected because
You don't have
the
e-filing.
page limitation, and then she filed it. I know it was mailed in, but I can tell you how. Mm,
Yeah, we don't have e-filing for criminal, but if it was mailed in, it should have gone to criminal. They didn't put anything in that they received.
It was mailed as well, but let's check on record too.
Mail the 26th,
June,
June.
do you have a copy with you?
Yeah, that's the, that is not the, it's just, I didn't print that one.
Yeah, if you can email it to Judge Sherman's courtroom at lansingmi.gov.
I just got it at the one with the proof of service. I didn't want to print the whole one.
Well, this has the substance. Right? This has the previous person again. And of course, Your Honor.
Yes.
copy.
Okay, yeah, that's fine. I just,
We can make a copy of it.
this is the one, this is for the,
Proof of the- believe so.
I thought it just came off. Okay, it does. All right. I just want to make sure I got the proof of service on it.
I can make a copy of this. Yeah.
No, no, well. No, I'm sorry.
I believe that you can exchange.
Well, I log in because I use. Yeah. So.
Yes, please. We also don't pass what they're gonna make you push the button there when I do it, you can push the button. All right, back on the record, People versus Lombardi, and I did have an opportunity to read your brief. I'll let you make the arguments on the record for whatever points you want to hit at this time. You can proceed.
Thank you. All right, as the court knows, we're here on our motion to dismiss the criminal complaint that was filed against Ms. Lombardini back on February the 21st of 2024. I think, as the court's well aware, this case involves allegations of violations of the Michigan Campaign Finance Act with respect to two organizations, Michigan by Michigan and also Michigan Citizens for Responsibility, for which Ms. Lombardini served as treasurer and president, respectively. And the complaint actually has four different counts, 3 misdemeanors and 1 felony. Counts 1 and 2 allege that Ms. Lombardini failed to file a statement of organization for both entities as required by the Campaign Finance Act. Count 3 alleges that she failed to file a campaign statement for Michigan by Michigan as required by the Act. And then count 4, which is the felony count, alleges that she uttered and published a false statement in an affidavit submitted to the Secretary of State defending against a citizen complaint alleging violations of the Campaign Finance Act. I know the court's had the opportunity to take a look at the briefs. They're voluminous. And what I think I want to do today, with the court's permission, is really focus my argument on the primary 2 reasons why the charges brought against Ms. Lombardini by the Attorney General can't go forward. Because with all due respect, these are so clear that I don't think it's necessary to go any further. First and foremost, none of the charges that were brought against Ms. Lombardini were none of the charges that were brought were timely filed. In fact, they were brought by the Attorney General's office a year and a half too late. Second, with regard to the uttering and publishing count, which is really the only felony count, as I mentioned, it violates the exclusivity provision of the Michigan Campaign Finance Act. And by that I mean, the Act itself indicates that there are exclusive remedies or provisions within the Act for enforcement of the Act. Uttering and publishing is not one of those. So let me speak first to the issue of untimeliness. In order to appreciate why the present charges are untimely, I think it's essential to understand the general statutory scheme laid out by the Act for addressing violations of campaign finance law. In a nutshell, the Act requires the Secretary of State to spearhead any investigation into any citizen complaint alleging the violation of the statute. When such a complaint is filed, the statute expressly requires that the Secretary of State, quote, shall investigate, end of quote, the pending allegations. And that's found in MCL 169.215.9. The Act also makes clear that the investigation is time sensitive. Secretary of State has 45 days following the filing of an answer and rebuttal to determine whether there's a reason to believe a violation has occurred. And I think when you think about it in a broader sense, it makes sense because elections and the like are time sensitive. There's a specific time frame in the context of when an election is to occur. So in order to investigate any violations, you have to have tight time limits, if you will, and that's what the statutory language provides. And in the face of any violation, it, that being Secretary of State, has 90 days to work out an informal resolution by entering into a conciliation agreement with the violator. If such an agreement can't be reached for whatever reason, then the Secretary of State has 2 options. It can either refer the matter to the Attorney General for the enforcement of any criminal penalty. That's important language. For the enforcement of any criminal penalty provided by this Act, or commence a hearing for enforcement of any civil violation. And if the Secretary of State chooses the former option, the statute gives very precise instruction to the Attorney General as to how to proceed. It says the following, and I think this is the crux of the untimeliness argument. No later than 60 days after a matter is referred to the Attorney General for enforcement of a criminal penalty, the Attorney General shall determine, and I want to underline those words for the court. The Attorney General shall determine within the 60-day window whether to proceed with enforcement of that penalty. And that's really the crux of our argument with regard to untimeliness. There's no dispute that the Secretary of State referred this case to the Attorney General on June 3rd, 2022. Therefore, within the 60 business days, the Attorney General should have decided, i.e., shall determine whether to proceed with enforcement of a criminal penalty under the very plain language of the statute. That's not what the Attorney General did, Your Honor. It didn't enforce anything within the 60-day time period. Instead, on August the 30th, 2022, the 60th business day, it sent a letter to the Secretary of
You said
State.
August 30th, correct?
I'm sorry,
I'm just making sure I heard you, but you said on August 30th.
correct. Yes, correct. It sent a letter to the Secretary of State, which simply stated the following. The Attorney General has determined to proceed with an investigation into the potential enforcement of any appropriate criminal penalty. And with all due respect, that letter flies in the face of the very explicit language of the Campaign Finance Act. The statute doesn't say that the Attorney General can, quote, potentially enforce a criminal penalty by opening an investigation to determine whether a crime has even taken place. That's what the Secretary of State just did in deciding to refer the case to the Attorney General. Instead, the statute requires the Attorney General to make a decision to actually enforce criminal penalties. And the only mechanism available for enforcing criminal penalties is bringing criminal charges. Everyone agrees that the Secretary of State didn't ultimately bring charges in this case until February. In fact, February 21st of 2024. It's a year and a half after the 60-day enforcement deadline. And respectfully, Your Honor, this case isn't even a close call with regard to those time limitations. The Attorney General completely and utterly blew the statutory timeline for filing its complaint. So what does the Attorney General say, or how do they try to justify clear delay? Well, it essentially takes the position when the statute directs it to, quote, proceed with enforcement of a criminal penalty. It doesn't need to actually enforce anything. Instead, the Attorney General says it only needs to, quote, formally open an investigation into whether a criminal violation in fact occurred. But that argument doesn't hold up for three separate reasons. First, it substitutes the word investigate for enforce, even though the legislature showed in the act itself that it used those terms separately. It's the Secretary of State who is statutorily charged to investigate whether a crime occurred. And if the Secretary of State determines a crime has been committed and refers the matter to the Attorney General is then charged with enforcement of a criminal penalty. If the legislature simply wanted the Attorney General to open another investigation, it would have used the word investigate, just like it did in directing the actions of the Secretary of State. Instead, it used the word enforce, and that's critical. Second, the Attorney General's position flies in the face of the deliberate language it used in its August 30th letter. Again, the Attorney General announced its intent to proceed with an investigation into the potential enforcement of an appropriate criminal penalty. If the Attorney General truly believed that the word enforcement meant that it only needed to open an investigation, then it wouldn't have needed to say it was potentially enforcing a criminal penalty by opening an investigation. It used the word potentially precisely because there is a difference between potentially enforcing a criminal law by investigating whether a violation has occurred, and two, actually enforcing a criminal law by filing criminal charges. And the act requires the latter. Third, the Attorney General's interpretation of the act obliterates the statutory scheme for moving campaign finance cases forward to a quick resolution. The statute repeatedly sets deadlines measured in weeks and months to keep a case moving. However, the Attorney General insists on looking outside the statute by contending that it has 6 years to bring charges under the catch-all limitations period borrowed from the Michigan Criminal Code. That interpretation renders the 60-day period in the act meaningless. What does it matter if the Attorney General decides whether to open an investigation within 60 days of a referral if charges can be brought thousands of days later? That makes no sense and is in direct violation and directly contrary to the clear statutory language. This court should not interpret the act in any way that eviscerates the highly regimented series of deadlines established to quickly resolve campaign finance violations. The analysis here is really very simple and straightforward. The statute gives the Attorney General 60 days to file charges. If failed to do so, those charges must now be dismissed as untimely. So the second argument, with the court's permission, I want to highlight pertains to the felony count, the uttering and publishing charge. It's the only charge brought by the Attorney General's office, the only felony charge. And clearly, it's the only charge that is not a part of the Michigan Campaign Finance Act. It actually comes from the Michigan Penal Code. It's found at 750.249. And the problem with the Attorney General's effort to import that charge into this prosecution is that the act doesn't allow the Attorney General to charge campaign finance crimes that aren't contained within the act itself. The act specifically says, and again, as to this argument, this language is critical. The remedies provided in this act are the exclusive means, and I want to emphasize that. Exclusive means by which this act may be enforced and by which any harm resulting from a violation of this act may be redressed. And the word exclusive, I respectfully submit, means exactly what it says, exclusive. The Attorney General has to choose from the criminal penalties within the act. It can't go outside the act to remedy campaign finance violation. So what does the Attorney General say in response? I think it has two arguments. First, it contends that the uttering and publishing charge is appropriate because the uttering and publishing charge contains a specific intent element that isn't found in the offense contained within the act. But that argument really misses the point. The issue isn't whether uttering and publishing duplicates a remedy within the act itself. The problem is that uttering and publish isn't contained within the act, which provides the exclusive remedies for campaign finance violation. And that exclusivity provision makes this a very different situation than the case cited by the people, which is the case of the People versus Hall, the only case that they cite in support of their position. In Hall, the Michigan Supreme Court expressly noted that the statute at issue did not contain an exclusivity provision. And here, the Michigan Campaign Finance Act clearly does. There's no question about that. And second, the Attorney General argues that the word remedy in the act only refers to civil remedies. As an initial matter, that ignores the plain meaning of the word remedy. For over 100 years, the Michigan Supreme Court has used the word remedy to refer to both a civil or a criminal remedy. And we cited case authority for that in our brief. And that's because the word is broadly defined as the means of enforcing a right or redressing a wrong. The Attorney General's interpretation also ignores the plain language of the act. When the statute talks about the exclusive remedies that may be enforced, it is referring directly back to the enforcement provision found in MCL 169.215(10). That provision, in turn, encompasses both civil and criminal remedies. Specifically, it provides for both the enforcement of any criminal penalty provided by the Act and the enforcement of any civil violation. So the legislature knows how to distinguish between civil violations and criminal penalties when it wants to. It did not use either of those terms to limit the meaning of the word remedy in the exclusivity provision, because it is plainly intended for that provision to apply to both. So, Your Honor, for these reasons, we believe the language of the statute is very clear on both the issue of timeliness and exclusivity. And we're simply asking the court to give the words used by the legislature their plain and ordinary meaning. However, to the extent that the court believes there's any ambiguity in the statutory language, I want to close by reiterating the rules of construction that apply in a criminal case. Under the rule of lenity, a defendant should not be forced to run through interpretive gymnastics to reveal the meaning of a criminal statute. Penal laws are to be strictly construed with all doubts resolved in a defendant's favor. And that's found in the People versus Arnold case that, again, we cited in our brief. The Attorney General would have it exactly the opposite. Wants the court to interpret the word enforcement to mean investigation and exclusive to mean non-exclusive. And with the utmost respect, these are two simply untenable positions. The statute says what it says and should be enforced as it was written. And for that reason, Your Honor, we're asking the court dismiss this case in its entirety. Thank you very much.
I thought you made another point also about a violation of First Amendment. Did you not want to address that?
I did, Your Honor, and I'm happy to talk about that, but with all due respect, I think it's easier, and I don't mean disrespect at all. I just think that I'll rely upon what we've set forth in our written brief on that issue. Thank you.
Thank you, Your Honor. I know Your Honor just read the briefing, and so I'm not going to rehash everything we said in the brief. So I hope to just run through a few of the highlights from our arguments, and primarily would like to answer any questions Your Honor may have about the arguments. And so defendant's primary argument is that the Campaign Finance Act precludes the charges brought against her in this case. As to the misdemeanor charges, and it looks to section 15 sub 14 of the Act, which provides the Attorney General 60 days to determine whether to proceed with enforcement following the Secretary of State's referral. And defendant's argument is that this creates a statute of limitations applying to the filing of charges, and creates a 60-day statute of limitations. The problem there is that statutes of limitations contain specific language, especially in the criminal context, where they provide when an indictment may be found and filed. And here, even if we weren't going to look for that specific language, we expect to have something about charges or filing or an indictment or a complaint, but we have none of that language. Instead, the legislature chose to use this broad and general language to determine whether to proceed with enforcement. We have to presume that that choice by the legislature was intentional, to use this broader language rather than specifically referring to charges or filing. Here, the AG complied with this requirement by issuing its letter indicating that it was going to open a formal investigation and the possibility of criminal charges following the Secretary of State's referral. That was the determination the Attorney General made to proceed with enforcement. Now, defendant emphasizes.
Let me stop you right there, just because I have a question.
Of course.
As we talk about section 14 of the NCL 169-215 section, I'm at section 14.
Yes.
Where the language states no later than 60 days or business days after the matter is referred to the Attorney General for enforcement of a criminal penalty, because we agree or do we that there's one of two penalties under the Act.
Correct.
Correct. There's civil penalty or criminal penalty. Correct.
I believe it refers to civil violations and criminal penalties.
As it relates to the two options that the Secretary of State has. They can keep it in-house and move civilly, correct?
Yes.
Or they can refer to the AG to enforce a criminal penalty, correct? Okay, and so if the language says no more than 60 business days after the matter is referred to the Attorney General for enforcement for a criminal penalty, the Attorney General shall determine whether to proceed with enforcement of that. Does that not require that determination to take place within the 60 days? Meaning, your argument is not they didn't have, the AG doesn't have to bring charges within the 60 days, but needs to take some action to determine.
Correct.
It doesn't say to take action to determine. It says no later than 60 business days after the referral that they shall determine whether to proceed.
Yes.
So your interpretation or the AG's interpretation is that the proceeding could mean just an investigation.
Correct. And that would be the determination to proceed with enforcement. That first step of enforcement is a criminal investigation. That's how law enforcement is initiated. That's how it proceeds. And again, we have to work with the more general, broad language that the legislature chose to use rather than file charges or when indictment may be found and filed. And so our position is that it doesn't specify the exact action that the Attorney General must take. Instead, uses this broad language to determine whether to proceed with enforcement is what occurred here.
So your argument is enforcement means or includes criminal investigation.
Correct.
What
would be
authority
proceeding.
do you have to support?
Your Honor, all I can point to is our dictionary definition of proceed, which is
Well, I want to
initiate.
talk about enforcement, not proceed.
Yes,
I understand clearly what proceed means, and I don't think that either side is disagreeing what the term proceed means. I think the disagreement is what the word enforcement means. That's what we want to talk about, not proceed. Where did you get your definition of enforcement of the penalty?
Your Honor, just based upon the plain language meaning of enforcement, here we're saying proceed with enforcement means initiating criminal proceedings. Criminal proceedings are initiated through an investigation. And if the legislature intended to say file charges, that's what it says. Filing or charges would have used more specific language than this broad language. Proceed.
I understand that to be your argument, but I'm trying to understand where are you getting this definition? Is there a legal basis that you're getting that?
I'm not aware of any definition of statute or any definition of case law. So in that sense, no, there is no.
As to what or how we should determine or interpret the term enforcement.
In this context, correct.
Okay, you can proceed.
So, Your Honor, that's our plain language argument, is that the legislature gave no indication in the text it was intended to create a 60-day statute of limitations. Looking at this from a policy perspective, the 60-day statute of limitations would be terrible policy. There's a reason that statutes of limitations are typically measured in years rather than days. And that's because criminal charges are weighty, and much more weighty than a civil violation. And so the defendant points to the tight deadlines otherwise set forth in the act in terms of investigating potential violation. But it makes complete sense that once we reach the criminal sphere, those deadlines can no longer be tight, that we have to then conduct a full investigation and then proceed through the criminal courts, which is going to take time. And there's a reason the investigation in this case took over a year, and that's because we took criminal charges seriously and wanted to conduct a thorough investigation. And so it'd be hard to believe that the legislature would intend to reduce that window for filing charges from 6 years to 60 days. We would argue that the language of the statute does not indicate that's what the legislature intended. So looking to the uttering and publishing charge, which is the felony charge here. In the briefing, the defendant looked at both section 15 sub 8 and section 15 sub 17. Sub 8 creates a civil violation for filing a false statement, a complaint. Our analysis of that provision is where we refer to Hall, because we read defendant as arguing that there's a conflict between sub 8 and uttering and publishing. So we went through the Hall analysis, explained why there's no conflict there. So that's where our Hall analysis applies as to that argument that was raised in the briefing. As to sub 17, the exclusivity of remedies provision, In our brief, we go through the text line by line, explaining why the provision concerns who may enforce the provisions of the Campaign Finance Act. What it does is it prevents outside parties, other than the Attorney General, the Secretary of State, from trying to enforce the act through the courts, but does not bar the Attorney General from bringing charges under the criminal code where appropriate. So again, that a part of our argument there goes to the definition of remedy, where we looked at Black's dictionary, which indicates that typically refers to the civil context. Defendant cites one case from 1910, which is Sisson v. Lampert, 159-509, indicating that the court has at times referred to remedies to refer to criminal or civil. But even later in that same opinion, the court distinguishes between a civil remedy and a penal provision. And so these are different terms. And remedy does typically refer to a civil violation. And so that goes to our plain language analysis. I think an even simpler way to look at this, Your Honor, is that the uttering and publishing charge in this case is not enforcing the Campaign Finance Act. The allegation of the complaint as to that count is not that the defendant violated a provision of the Campaign Finance Act, but she violated MCL 750.249. For that reason, too, this provision doesn't apply here and certainly does not bar the Attorney General from bringing charges under the penal code and does not immunize the defendant from prosecution for such violations. Your Honor, I'd be happy to answer any questions about our First Amendment analysis. But otherwise, I'll follow the defendant's lead and not address that further here.
Okay, I have some questions about the statute limitation issue.
Okay.
So the Campaign Finance Act, it outlines a lot of deadlines. We don't disagree with that. And so is it the Attorney General's position that once they, let's say I took your argument that enforcement is synonymous with investigation. Does it not give a timeline for how long you get to investigate?
Our position is that it is not, because then the charges enter the criminal sphere. The typical statute of limitations in the criminal context applies, which provides 6 years to conduct a thorough investigation and bring charges, not this type window of 60 days that a prosecutor or the Attorney General has to rush to the courthouse to file charges while an investigation is still pending. Why
Would that be true versus the contrary, which if you read section 17 says this is the, except as provided in section 57, this remedy provided in this act are the exclusive means by which this act may be enforced and by which any harm resulting from a violation may be redressed. Why does that not matter? And we now go into the criminals, even though they state here that this is the exclusive way to address it.
Yes, and Your Honor, that goes into a little bit more in depth into the weeds of our argument in the brief. And so how we read 17 is the first 2 lines apply to attempts to civilly enforce the provisions of the act by a layperson or by an outside organization. And so the first.
What, you said the first 2 lines go to civil?
Correct. The first 2 sentences are 2 sides of the same coin. The first line says, get the exact language here, there's no private right of action, either in law or in equity. And then the next line says the remedies provided in this act are the exclusive means. And so again, that's limiting who may attempt to try to enforce the act through the civil means, a civil action.
But it doesn't say that. It doesn't say anything about only civil. I can understand the interpretation, I think, about equity, because we know that's civil, correct? And obviously taking a private right of action would mean it has to be civil. However, when we go to the next sentence, it's a separate sentence, except as otherwise provided in section 57, the remedies provided in this act are the exclusive means by which the act may be enforced and by which any harm resulting from this violation may be redressed. So you're saying because they use the word remedies, that automatically means they're only talking about civil?
I would say that is a clear indicator that they're still talking about civil following from the first sentence. And so this is essentially the second half of what is stated in the first sentence.
And so you dispute the position of the defense is, which is that the term remedies in legal context is used in both criminal and civil matters.
I would say to the extent that's true is very rare. They only cite to this one case from 1910, as I point out, that case even later in the case distinguishes between civil remedy and a penal provision. And so remedy, and this is from Black's too, typically refers to the civil context. I think that's also demonstrated, Your Honor, by the third sentence of that provision, which then talks about criminal penalties specifically, seemingly creating a distinction between those first two sentences and then who may enforce criminal penalties. That's the Attorney General.
Correct. And I think that, but I think that also gives emphasis to the second sentence being applicable to civil and criminal, because they're now explaining who can only enforce. The second sentence says that this is the exclusive means by which this may be enforced, and then it's making it clear if you want to go the criminal route, only the AG can do it. So that means the second sentence is not just talking about civil, we're talking about enforcement.
I think I would.
Otherwise,
I understand.
If they use the word criminal as it relates to the third sentence, and then they only wanted to be relating, they only wanted the first and second to relate to civil, then they would have used civil, correct?
I think I would look again to private cause of action, the first sentence, making it clear to the reader that we are talking about the civil context.
I agree to that,
And I would read that to
But-
continue into the second sentence.
but the second sentence doesn't use the civil or criminal. And they're specifically using language in section 17 that will distinguish or have the reader understand when they're talking about a private cause of action, when they're talking about a criminal action. And so the sentence that doesn't say either, why would we not construe that to mean remedies for both, when it's clearly stating this is the only way that any harm, that any would be civil or criminal? No?
Again, reading this through a civil lens, I would see harm as harm to an individual attempting to enforce the act.
Where does
on
it say
their own.
that?
Again, that's reading from private right of action, the first sentence, and then the choice of the word remedies in the second sentence, which again, we would read as signifying the legislature is still referring to the civil context.
Any further argument?
No, Your Honor, except that to the extent defendant reads 17 as concluding prosecution under the penal code, I would again point out that prosecution under the penal code is not attempting to enforce a provision of the Campaign Finance Act. That is a separate charge based upon conduct that is covered by the penal code.
Okay, so the count one under and publishing, your position is not, that's an act that was separate from the Campaign Finance Act by alleged violations.
Correct. The alleged violation is not a violation of the Campaign Finance Act, but a violation of that criminal statute.
Thank you.
Thank you, Your Honor.
Any re-argument?
Your Honor, only that in response to the last argument, this all arises out of the allegation of a violation of the Campaign Finance Act. So, again, with all due respect, what the Attorney General is trying to do is parse words here and avoid the very plain language of both sections that the court is focused on. With regard to timing, 60 days is in the statute for a reason. And respectfully, they blew it. We're well beyond the 60-day time frame. And with regard to the exclusivity provision, what they're attempting to do in a Campaign Finance Act case, there's no question that that's what this case is about. They're attempting to import a statute, the uttering and publishing statute, when, as the court indicated in section 17, it clearly indicates that you can't do that. You can only charge violations of the campaign finance law, acts, if you will, that arise under the act. You can't import these other statutes. Respectfully, Your Honor, this case should be dismissed.
I think I'm hung up on the people's definition or interpretation of the word enforcement. I want to go on research issue real quick. I don't think that it was, I think that the people probably addressed more of the word, what proceed means, which was not the issue that I have. It's the interpretation of enforcement and what that means in this case. So let me go and. So, is there somebody waiting for us?
I'm sorry.
Is somebody need us in here? Oh.
It is. Yeah, exactly. Oh. Okay. Mhm. Oh, very good. Yeah. Oh, I know. I know. Yeah. Oh, yeah, yeah, yeah. Thank you. Mhm. But it's the same. Was one for one of the other.
That's true.
Mhm. Let's do it. Oh, that's great. Work. Okay. Mhm. Mhm. Right. You can't. It's, you know, six figure. Bumps. Right.
She said, I can't. No, I can't. Because, no, I cannot do a transfer. No, we can't do that because it's not secure.
Okay. Yeah. Mhm. Yeah.
Yeah, kidding.
Very nice person. Okay. Really? Interesting. Mm-hmm. That's great. That's really good. Yeah, for sure. That's good. Yeah. Mhm. Good.
Yep.
Mhm.
Something shiny and then have the streets.
Yes, ma'am. Walk back. Yeah, there you go.
It's on the wall. So I just did not want to be, all of a sudden take too long. And I did not want anyone waiting on me. So I was there.
I was gonna ask you that, what he was saying, but I think this is just for.
Because she wanted to change it.
Yeah.
Back.
To what, to take. Jesus to the-
But,
and go next to-
yeah, cause, wait, they said, let me see, cause magistrate arraigned, but that's not,
26.
that has to be just for. I think it is, I would actually need to double check them.
Mhm. Okay. That's great. Mhm. Okay. Yeah. Yeah, right. Crazy. Right. Mhm. Mhm. Okay. Okay. To-
Yes, a little less. Somebody else that did over, so I think we were still. Trustees. Special. So, yeah. Okay. Yeah. So. and then
Oh, okay. I was like, it's awfully bright out, sorry.
Okay.
I thought you were serious. Okay, sorry.
No. Mm. Okay. No.
Changed in the last 10 minutes from now. No.
Correct.
Mhm.
So. I'm gonna look at the vision for once, because I was talking to Will at home, who is now transferred over to corrections.
Gotcha.
Just, no,
Yeah.
it was just. And she and I. So. Why they crazy?
I mean, she's her judge today, so she's saying, well, right, like right now, like she wants to. I would ask her, just, I don't know. Like, take.
This man or something.
I'm trying to order it. But does your judge work back on there now? That's what she told me.
And she.
Judge did.
And I asked her. We also tattooed it around there.
See what I'm saying? So I don't know, I don't know, maybe.
That's what I'm saying. It's just huge.
Mhm. But why, I mean, why do you have this fight?
back on the record, and I had an opportunity to review case law. I wanted to review a couple of issues. I think the easiest way for me to do this is to start with the First Amendment argument. I disagree with the defense position on the First Amendment argument. I don't believe that the charges violate Ms. Lombardini's First Amendment, so I'm throwing that one out. Now, I tend to see the defense's argument to somewhat overlap as it relates to the issue of the statute of limitation and then the exclusive remedy. I think I kind of touched on that a little bit when I questioned the people about section 17 of MCL 169.215. And so taking the statute of limitation, even if we just look at the language of the statute, section 9 of that statute says the Secretary of State shall investigate the allegation under the rules promulgated under this act. If the investigation involves the Secretary of State, then or the immediate family or of the Secretary of State, or a campaign or committee of which the Secretary of State is connected directly or indirectly, the Secretary of State shall then refer the matter to the Attorney General to determine whether a violation of this act occurred. So I interpret section 9 to be very clear that it is the job of the Secretary of State to investigate the allegations to determine whether or not there's been a violation of the act. And if the Secretary of State, for one of the reasons mentioned in section 9, is not in an appropriate position to do that investigation themselves, then they would refer it to the Attorney General to do the investigation. I believe section 9 is very clear. Section 10 says no later than 45 business days after receipt of a rebuttable statement submitted under section 5, or if no response of a rebuttal is received under section 5, the Secretary of State shall post on the Secretary of State's internet website whether or not there may be reason to believe that a violation of this act has occurred. I'm going to skip down. Regarding to where it says under section 5, after we get that where it starts, says if the Secretary of State determines that there may be reason to believe that a violation of the act occurred, the Secretary of State shall endeavor to correct the violation or prevent a further violation by using informal methods such as a conference, conciliation, or persuasion, and may enter into a conciliation agreement with the persons involved. In this indication, or in this matter before the court, there wasn't a conciliation that was entered into, although I believe one was attempted. Unless violated, a conciliation agreement is a complete bar of any further civil or criminal action with respect to the matters covered in the conciliation agreement. Again, in this matter, we don't have a conciliation agreement. It goes on later to state, if after 90 business days, the Secretary of State is unable to correct or prevent further violations by these informal methods, the Secretary of State shall do either of the following. It's two very clear avenues. They could either A, refer the matter to the Attorney General for enforcement of any criminal penalty provided by this act, or they can commence a hearing as provided in section 11 for enforcement of any civil violation. I don't interpret the word enforcement as being ambiguous. I think it's very clear. And so the word enforcement, or to enforce a penalty, right, well, before we even get to penalty, the word enforcement would mean to take the authority under a rule of law and to make sure it is obeyed. That's the actual legal definition of enforce. It's not to investigate to see if we can do that. I don't think that the intent of legislation was to open up the avenue, at least as written in this section here, which is section 10, to open up the avenue for a new investigation, because then they would have said that, because in section 9, they made it clear whose duty it was to investigate. Section 9 again, the Secretary of State shall investigate. And if they can't, for the reason stated, then the Attorney General will do the investigation. That's not what happened here. Secretary of State did their investigation. The people have not provided any information in their brief or otherwise that supports that there was some reason why the Secretary of State was not in the appropriate position to do the investigation as provided by Section 9 of this statute. If we go down to Section 14, no later than 60 business days after a matter is referred to the Attorney General for enforcement of a criminal penalty, the Attorney General shall determine whether to proceed with enforcement of that penalty. And so I believe that the Attorney General completely blew that deadline. I don't believe that this is unclear, that it gives them the opportunity to open or take a second bite at the apple of reinvestigation. The investigation was to take place initially by the Secretary of State. That's clear in Section 9. The Attorney General had more than enough opportunity in Section 14 to do their own investigation because it gave them 60 business days to do that. And then they need to no later than those 60 business days determine whether or not they're going to proceed with an enforcement of that penalty. The notification or information that was provided from the Attorney General at that deadline was not that the Attorney General was proceeding with an enforcement. They had not determined it within those 60 days. You got to determine it within the 60 days is what it says. Doesn't say you get after the 60 days to determine it. That's what an investigation is for. The investigation is when you determine to bring the charges. This doesn't say that they have 60 days to do an investigation or to decide to open an investigation, to be clear. It says that they have 60 days to determine whether or not to proceed with enforcement. Within those 60 business days, the AG did not make a determination, and that violated the statute. Where I believe this overlaps is as it relates to the exclusive remedy, which is what the defense is arguing as another avenue by where this or the defendant's rights would have been violated. And that would go down to Section 17, where it says, except as otherwise provided in Section 57, there is no private right of action either in law or in equity. I think that first sentence makes it clear, because they state either in law or in equity under this act that they are giving an avenue to cover both civil and criminal, not just criminal, or not just civil. That's why they used or. Except as otherwise provided in Section 57, the remedies provided in this act are exclusive, or the exclusive means by which this act may be enforced, and by which any harm resulting from a violation of this act may be redressed. The prosecution is arguing that because the word or the use of the word remedies is in that sentence, that tends to mean that the legislation only was addressing a civil remedy. I disagree. I took the time to not only review the defense case that they cite where the use of criminal remedy is, but to see just in the 30 minutes that I took, how many other times I can see the word remedy used in the criminal context. It's used numerous times, specifically in Mack versus City of Detroit, which is 243 Mish App 132, a 2000 case, not a 1900 case. The word criminal remedy is used 3 times, specifically criminal remedy. There's other cases, and I can cite a few if necessary, where the word remedy is used to describe or described in a criminal context. But when I also look at how the word remedy is used here, the word remedy as it relates to an action in law doesn't just mean remedy as we use it in the civil context, because sometimes we know the definition is given by Black's law is typically used in a civil matter to affix a remedy. But we can also affix a remedy in law, and we're not talking about a civil matter or attaching a dollar amount. For example, if there is a violation of a person's right, Fourth Amendment right during an arrest, the appropriate remedy would be a dismissal. We know that the word remedy is used in multiple contexts. I believe in this particular context, the word remedy was used to discuss both civil and criminal, because it goes on to say that this is not only the exclusive remedy, but also the only way any harm resulting from a violation of this act can be redressed. It's a catch-all at this point. It's covered both what you may construe as civil and anything else, because it says any harm resulting, that any harm would also include criminal harm. Then it goes on to emphasize, I believe, in the last sentence, that criminal penalties provided by this act may only be enforced by the attorney general. It did not say may only be investigated by the attorney general. It said enforced. The expectation, I believe, of the legislation was for the investigation to be primarily held by the Secretary of State, and then for them to determine which avenue they wanted to move forward with, and that the investigation would be primarily handled by the AG if it was inappropriate for the Secretary of State to do so. In this case, the Secretary of State did the investigation, made the referral to the Attorney General. The Attorney General has an opportunity within those 60 days to do further investigation to decide whether or not they are going to proceed with enforcement of the penalty, because that's what it's being referred to them for. Within those 60 days, it does not, I have nothing here that shows me that the AG had made that determination within the 60 business days. So for those reasons, I believe that there was a violation. Lastly, the issue as to whether or not uttering and publishing was a separate claim. I tend to agree with the Attorney General that it was a separate claim, and that was not being because of the specific intent of the uttering and publishing. And so count 1 will remain. Counts 2, 3, and 4 will be dismissed. I don't believe anyone provided me an order, but if the defense can provide an order to the court.
Your Honor, just to be clear, it's actually, I think the felony count is actually count 4. So I think what the court is ordering is the dismissal, counts 1, 2, and 3, and then count 4. No?
Count 1 is the uttering and publishing.
Oh, maybe.
Originally,
Originally that was the case.
remember the court wanted us
Oh,
to
that's
change, amend it because of the way it was entered in the court system. And then we sent in
Very
an
well.
amended complaint.
Okay, my mistake. I think you're right about that.
I'm trying to see if I was even a part of that, but I don't know. All I know is that my complaint has count 1 as uttering and publishing.
All right,
That
very
is
well.
correct.
I
And
think,
so I believe
the
that the
Attorney
campaign
General
finance,
is-
the charges that stem from the Campaign Finance Act was the issue of violation, I believe. So those were the ones that I was dismissing.
very well.
Okay.
Two things. With regard to the preliminary examination, which is scheduled for this Thursday, when I interviewed one of my witnesses, who is Adam Fracassi, he indicated when he got his subpoena, he had noted the court's name on it. And he indicated that he did know your honor. And
We
he
worked at the AG's office in the election division, and we sat next to each other, and we have a relationship outside of.
And he wanted me to bring it up. And once I had interviewed him, I did let Mr. Cranmer know and his co-counsel, Mr. Gleason know, and my notes indicated that I had that conversation on July 1st. And I know I had to bring it up to you, who indicated that you were friendly. I don't know if it causes a conflict because he obviously will be a significant witness on this case, but I had to bring it up to the court to see if there was in fact a conflict and let the court make that decision. And I had let Mr. let the defense know ahead of time, because I didn't want them to hear that for the first time when we were here to argue the motion, but I had to let the court know as well.
Oh, okay, yeah, I saw his name when I was flipping through the paperwork. We did sit next door to each other. We worked both in the same division at the Attorney General's office. I've had other cases that involved Mr. Fakasi. I don't have a personal conflict because I could still be fair and impartial. And I don't believe our relationship rises to the level of something that I would need to recuse myself because we worked together up until 2018. Yeah, 2019, I went to the Department of Corrections. And so, and since then, I have interacted with him only as it relates to my own campaign finance stuff, because I'm an elected official as well. And so I don't think any of those things would preclude me from being able to oversee the case.
I have no objection to having you hear the case. I just wanted to make sure the court was aware, because it really didn't lean on the motion, but I didn't want you to walk in on the preliminary examination and
see
be
he's a
caught
witness.
unaware if he was there.
Got it. So he's intended to be a witness.
Yes.
And then there was another name I noticed. She's gonna be, but Heather. We obviously work together as well at the AG's office. Obviously not Heather Bardini. I thought I saw Heather buying gasoline in here somewhere, but I could be wrong. But it would be a similar relationship, even if she's called. I don't know.
I am not aware
Former
that she would be
colleagues.
called as a witness, but I appreciate you bringing that to our attention as well. Did you have any other questions, Tim, on that issue?
Not on that issue.
Any other issues as it relates to proceeding on this Thursday? The timeline still works for Thursday, correct?
It does, Your Honor. Just to be clear, I assume we're doing it in person here in the courtroom.
Correct. And how many witnesses are you intending to call? Two witnesses, okay, so it shouldn't be long. And is the people planning to call witnesses?
Is it our intention?
I'm sorry, the defense, are you planning to call witnesses?
Unlikely, Your Honor. We'll have to see how it shakes out, but I would anticipate.
Okay, sounds good. And so if you want to present the order at that time, that will be fine when you return on Thursday. Any other issues for today?
Just if there's a form, so I could order the transcript.
Yeah, there's a form that you can get from Ms. Nash for the transcript.
Or again, remind me if you would, if the time we're starting on Thursday is.
9 a.m.
Thank you, Your Honor.
Thank you.